custody, though, you do have to go to Sarita Municipal Court on October 28th at 8:30 so you can get this matter taken care of. It's not going to go away. Do you understand that, Mr. Sandoval?
Yes, ma'am.
And if you don't show up to court on that case, they could issue another warrant for you. Do you understand that as well?
Yes, I do.
All right, you're all done for
All right,
today.
cool.
Thank you.
The court address for those in downtown Phoenix will be on your
I
paperwork.
can't see nothing, James.
Bond is set in your case at $5,000. That is secured. If you deposit that with the court, you will be released. You have written conditions that you are ordered to comply with. You may not have any contact with the alleged victim. According to police, that person lives in Texas. You may not leave the state of Arizona. So needless to say, you can't return to the scene of the alleged crime because that is allegedly in Texas. You have other conditions of release. I'll let you go over for yourself, but those do include, as I said, you may not leave the state of Arizona without advance permission from the trial court, no drugs without a valid prescription, no driving without a valid license. Everything you need to know is on your paperwork. If you'll step to your left, you can get a copy of that and hand the officers the headphones. Thank you very much. All right, Mr. Montoya, Jose Montoya, will you get the headphones on and come into the podium, please?
Señor José Montoya, por favor, póngase los audífonos e ingrese a la sala al podio.
You guys can't see over here. Let me fix this up for you really quick, guys.
All right, sir. If you have any trouble hearing me, well, let me say this. Can you hear the interpreter?
Can you guys see now? Is everybody good? Can you guys
Sure.
see? Let me know.
Yes.
All right. If you have any trouble hearing them, you might want to plug your other ear so that you can hear her better.
Cool. Can you guys hear her too? Can you guys hear
All
the
right.
interpreter?
Sir, may I have your full name and your date of birth?
And it looks like Polk County didn't happen today, so next time.
José Antonio Jacobo Montoya, 18 de abril de 1967.
¿Qué fecha?
18 de abril de 1967.
¿Qué?
José Antonio Jacobo Montoya, April 18th, 1967.
All right. Thank you. You have been arrested on one allegation of failing to show a driver's license or other identification when driving a vehicle. That's a Class 2 misdemeanor. There is probable cause for it. I'm not appointing a lawyer for you, though, because I am going to release you, and we don't appoint lawyers in this kind of misdemeanor case unless you are given a bond.
That's wild.
So your next court date will be in 3 weeks. It is October 21st at 9 o'clock in the morning in the Peoria City Court. That address will be on your paperwork. As I said, I am releasing you on your own recognizance. You are ordered not to miss any court hearings. Do not possess any drugs without a valid prescription. Do not drive without a valid driver's license. Everything else will be on your paperwork. If you step to your left, the officers will give you a copy and you can give them the headphones. Thank you.
Look, put it. Look. You tell me what looks better. Do you prefer the way I had it or this way right here? Because this is the way the screen looks. What do you guys tell? Is it blurry now?
All right, if the interpreter could make a general call for service, if you didn't already. If you did, you can just tell me.
No, Your Honor, the interpreter is not. Would you like the interpreter to also ask those who may need the interpreter to raise their hands?
No, it's not blurry.
¿Hay alguien más que requiera los servicios de la intérprete? En caso que sí, por favor, levante la mano.
Is it still blurry?
Okay, we see no hands. Thank you so much, ma'am. Have a great day.
Thank you, Your Honor.
Bye-bye. All right, Mr. Jackson Burhell, Trevon Jackson Burhell, will you please come to the podium? After that, Andy Sustaita, will you please go to the chair? Good morning, sir. May I have your full name and your date of birth, please?
Trayvon Jackson Burhill, 2/28/1997.
All right, thank you. You're here on one new case and a probation hold. In the new case, you were arrested for allegations of possession of a weapon by a prohibited person, possession of narcotic drugs, and possession or use of a weapon during the commission of a drug offense. Those are all Class 4 felonies. Unlawful flight from a law enforcement vehicle, that is a Class 5 felony, and reckless driving, a Class 2 misdemeanor. There is probable cause for all of those, and I am appointing a lawyer for you in this case. I am also appointing a lawyer for you in your probation case. You are on probation for armed robbery, a Class 2 felony, and the probation department will be filing a petition to revoke your probation based on this new arrest. So you will have a lawyer in your probation case also. Right now, you have slightly different court dates in the cases. Eventually, they will come together in the system, and you should end up with the same lawyer for both cases. The first court date is going to be in the new case. That will be October 8th at 8:30 in the morning. I believe that's this coming Wednesday. That is a status conference in the new case only in the downtown Superior Court. Your preliminary hearing will be Friday, October 10th at 8:30 in the same court. In between those, on Thursday, October 9th at 8:30 in the morning, you will go to probation court for a revocation arraignment and possible disposition hearing. In the probation case, the court finds that you will, in all reasonable probability, be revoked to prison, and so you do not have bail at all in your probation case. You are held without bond. In the new case, you have a $40,000 secured appearance bond and written release condition. You should not bother trying to post that, though, if you are still being held without bond in your probation case. You can talk to your lawyer if you have any questions about how that works, but just because you have a bond in the one case does not change the no bond hold in the probation.
Hey, Rachel, thank you for that daily.
Everything will be on your paperwork. If you step to your left, the officers will give you a copy. Thank you. Mr. Sustaita, Andy, and then Mr. Goodlow McGarry, will you go to the chair?
That was going to go to prison. We give you too much work, Evan.
Hello, sir. May I have your full name and your date of birth, please?
Andy Sustaita, 5/15/78.
78?
Yeah.
Okay, we have 76, so I'm going to put that in here. I believe the other one will probably be entered as an AKA or an alternate date of birth.
I got 3 stream money, so I got to keep up with everything.
But I will correct it in our system for today's purposes. All right, sir, you are here on 2 probation violation warrants. As you know, you are on intensive probation. And back on September 10th, so almost a month ago, supplemental petitions to revoke your probation were filed. That means you were already in probation violation proceedings, and then they accuse you of committing brand new violations after that petition to revoke had been filed. So these supplemental petitions allege that you committed violations of terms 3, 4, 5, and 15.
Oh, not 15.
All right. I'm going to give you a lawyer. It should be the same lawyer that you have for the already pending petitions. You need to go have a revocation arraignment hearing on both of these petitions, and that will be October 9th at 8:30 in the morning. That's 1 week from today. I don't know what other probation court hearings you may have already have had scheduled, but we are scheduling this one for October 9th at 8:30 in the morning. And pursuant to Rule 7.2C, the court finds that you will, in all likelihood, be revoked to prison in one or both of these cases, so you are held without bond in both of these cases. If you step to your left, you get a copy of your paperwork. Thank you. Mr. Goodlow McGarry. After that, Michael Dorn. Will you please go to the chair? Hello, sir. May I have your full name and your date of birth?
Sean Goodlow McGarry, May 2nd, 2005.
All right, thank you. You're here on a new case. You were arrested for allegations of discharging a firearm at a residential structure. That's a Class 2 felony. 2 allegations of aggravated assault with a deadly weapon. Those are Class 3 felonies. 2 allegations of endangerment. 1 of discharging a firearm in the city limits, and 1 allegation of disorderly conduct with a deadly weapon. All of those are Class 6 felonies, and 3 allegations of criminal damage as Class 1 misdemeanors. These are all alleged to have been committed September 27th of this year. There is probable cause for all of them. I am appointing a lawyer for you. Your next court date will be this coming Wednesday, October 8th at 8:30 in the morning. That is a status conference in the downtown Superior Court. Your preliminary hearing will be October 10th at 8:30 in the same court. Based on what's been alleged against you, the court finds that you pose an extreme risk to the alleged victims and a high probability of victim or witness intimidation or retaliation. There is a strong weight of evidence alleged against you, and if you are ultimately convicted in this case, which is a long time from now, but if you are convicted, Many of these allegations are prison mandatory. So on this basis, the court sets bail in your case at $100,000. It is cash
Damn,
only.
that
If
went
you
nowhere.
post it, you will be on an electronic ankle monitor on house arrest. Absolutely no contact with the alleged victims, whether you are in or out of jail, not through third parties, not through social media. Obviously, you cannot go to the scene of the alleged crimes. No weapons, no drugs, no alcohol. Everything else will be on your paperwork. If you step to your left, I'll give you a copy. Mr. Dorn, Michael Dorn. After that, Javante Cheatham, will you please go to the chair? Mr. Dorn, may I have your full name and your date of birth, please?
Michael Dorn, 12/24/78.
Thank you. You're here on one new case and one probation hold. In the new case, you were arrested for 2 allegations of possessing narcotic drugs for sale, 1 allegation of possessing dangerous drugs for sale. All of those are Class 2 felonies. 2 allegations of possession of narcotic drugs, 1 of possession of dangerous drugs. Those are all Class 4 felonies.
I only had one thing on me.
Talk to your lawyer about that. No, they allege you had 3 types of drugs. Also, using an electronic communications device to facilitate a drug transaction, also known as a wire charge. That is a Class 4 felony, and there is probable cause for it. I am appointing a lawyer to represent you. Your next court date is a status conference this Wednesday,
has
October
another trial?
8th at 8:30 in the morning, and a preliminary hearing will be October 10th at 8:30 in the same court. You are on probation for drug possession as a Class 4 felony, and the probation department will be filing a petition to revoke your probation based on this new arrest. So you will have a probation court date on Thursday, October 9th at 8:30 in the morning. That is scheduled as a revocation arraignment and possible disposition hearing. Oh, I apologize, officers. I need to reprint the probation one. I forgot to check any boxes. All right, just give me 1 second. Alrighty. Now, in the new case, based on your criminal history, what's been alleged, and the apparent large weight of evidence against you, as well as your potential access to illegitimate funds with which to post bail and flee the jurisdiction, bail is set in the amount of $75,000. That is cash only, dollar for dollar. In the probation case, that remains a Prop 200 case as of today, which means you are legally entitled to bail in it. The court sets bail in the probation case in the amount of $10,000. It is cash only. If you post these, you have written release conditions you're ordered to comply with in both cases. Those include calling your PO within 72 hours of any release. If you please step to your left, once we've got that reprinted, we will send it out.
So to be clear, I can have bail on both of those.
$85,000 cash only.
Okay. Thank you.
Mr. Cheatham?
You want to head up there?
85, that fool ain't going nowhere.
After that, I need Ramon Trujillo.
Ramon,
Where's Mr. Cheatham?
come on down.
Hello, sir. May I have your full name and your date of birth?
Javante Cheatham, 4/7/2006.
All right. You are here on 2 matters. I'll start with the most straightforward. That's the new arrest. You have been accused of armed robbery, a Class 2 felony, also aggravated robbery, a Class 3 felony, 2 allegations of possession of a weapon by a prohibited person, those are Class 4 felonies, 1 allegation of possession of a prohibited weapon, that's a Class 4 felony, and resisting arrest passively, that's a Class 1 misdemeanor. There is probable cause for all of those. I am appointing a lawyer for you in this case. And I note, because this is important for considerations of sentencing and potential outcomes in your case, there are at least 2 alleged dates of crime in this case. Ms. Gaunt, did you want to appear in this case?
I did, Your Honor. Brooke Gahn on behalf of the state.
Brooke?
Okay, apologies. I just caught your camera view on my left. Alrighty. I'm gonna keep going, but then I won't forget to come to you before I rule. All right. So, Mr. Cheatham, there's probable cause for all of those, and I am appointing a lawyer for you. I'll give you your court dates in a moment. Now, you are on probation and in the juvenile transfer, it's the JTOP program, the program that's intended to keep adult convicted youth from continuing to commit crimes.
Yes.
So you're in that court.
That's not
Yes.
working.
And there was already a warrant out for your arrest for failing to appear. Also, the probation department has filed a petition, they filed a term 1 hold, notifying you and the court they will be filing a petition to revoke your probation based on this new arrest. So at this moment in time, you're going to have court dates in 2 different courts in your probation court, because right now The JTOP judge has not booted you out of JTOP. Frankly, you should expect that, but that is up to that judge. It is not up to me. So at this moment on that warrant, which was a failure to appear warrant on October 1, 2025, and Judge Koval issued a warrant for your arrest. I'm going to give you a court date in his court, currently October 8th at 8:30 in the morning. He will see this, that you got arrested. His staff will see it. They may vacate this and just put you into warrant status and let you go, meaning probation violation status, and just let this matter proceed in probation court. It's up to Judge Koval, and I can't predict what he would do other than to say that in most instances, I believe they will not continue to see you in JTOP court. They will let this proceed in probation court. In the meantime, the probation department has filed this hold, notifying you and the court they're going to file a petition to revoke. So I'm also giving you a court date in probation court, which is the next day, October 9th at 8:30 in the morning. It's a probation revocation arraignment hearing, and that address is going to be on your paperwork. So I'm just going to let counsel know before I hear the state's recommendation on bail or release that this puts this status of still being in JTOP and now probation violation puts the court in a slightly difficult position in terms of what the court would normally do. And I'll let you know, Mr. Cheatham, in the absence of the JTOP warrant, I would be holding you without bail in the probation case. The court believes that you are very likely to be revoked to prison in that case and get some prison time in the new case if you are convicted. There does appear to be a strong weight of evidence against you in the new case with offenses committed on multiple dates. So with that allegation, the odds of you going to prison start getting very, very high, and the court would not normally allow a probationer to be out in the community when they are pending a likely revocation to prison. But so, Ms. Galt, what the court had been contemplating, and you can certainly comment on this, because it is not practically speaking possible for the court to issue a no bond order in a case and then in the same case set a bond. That is something that, procedurally speaking, I believe the sheriff's system cannot process. Now, so the court was inclined to go ahead and set bail in both and make that bail cumulative, because it is difficult to say, you know, what the charging decisions will be down the road, what Judge Koval's decision will be, and so this court was intending to set appropriate bails for everything. And what I was inclined to do, and then you can comment on what you think I ought to do, is in the new case, and let me double check that I saw your recommendation. I did. I was contemplating 50,000 secured, then in the probation hold, 25,000 secured, and in the JTOP warrant, meaning if everything else goes away and all he has is the JTOP warrant, 5,000 secured, which would be 80,000 secured. So you can go ahead and comment on that if you want, please, Ms. Scott.
Thank you, Your Honor. The state had initially requested in the new case a $75,000 secured appearance bond along with electronic monitoring if Mr. Cheatham is able to post that. That was based on his significant juvenile record. He has prior juvenile adjudications for 5 felonies, and 4 of which are for minor in possession of a firearm and 2 are for attempted theft. He allegedly robbed the victim at gunpoint, along with other armed accomplices. He is currently on probation for armed robbery. I believe that issue alone is really what gives the state most concern here, is that he is on probation for the same criminal conduct that he's before the court on today. When he fled from law enforcement, he was armed with a firearm with a Glock switch, which again increases his dangerousness in the community. So that's why we were requesting the 75,000 secured. In regards to the probation case, I certainly understand what the court is saying. The state had initially asked for him to be held non-bondable pursuant to Rule 7.2C. Again, because it's certainly the state's position that there is a reasonable probability that he will be sentenced to prison, given his continued engagement in this same type of very dangerous criminal conduct. But given what the court has indicated regarding the procedural status of that case, I think the court proceeding in the way that the court has outlined will likely achieve the same ends in terms of being able to safely protect the community. Thank you.
Hasta luego.
All right, thank you. And you do make a good point, and considering, the other cases that the court sees, I'll tell you, Mr. Cheatham, I was not aware, I'm not sure why, but I think your juvenile history didn't come across as fully in what I was provided, that your juvenile history indicated that level of ongoing activity. And so it's, the court is, I don't want to overweight the fact that you're young. But because the offense conduct that is presented is extremely serious, and so is your history. And the county attorney makes an excellent point about, we're talking about two dates of crime, two separate types of offenses alleged in the new case. One is the armed and aggravated robbery, as to which there is a substantial weight of evidence. Then there is the allegation that at apprehension, the running from the police and the Glock switch that they allege was literally on your body. And the court believes that what you present is a level of dangerousness that's far beyond what an average person born in 2006 is generally presenting to the court. So I believe that the court's inclination was,
I wouldn't be surprised if they turned them over to the feds,
based on the idea that you're young, and did not have the level of juvenile background and apparent fixation with weapons that your juvenile history and the current allegations and your current probation case strongly indicate. So the court believes you pose a real risk to people in the community, whether you are young and unassuming looking, that there's a lot of evidence to indicate it is risky to release you into the community.
This was done.
And the entirety of the non-participation in JTOP, all of that adds up to a picture that makes the court believe it is not safe to release you on anything less than a $75,000, hold on, I'll give you a chance to talk, a $75,000 secured appearance bond in the new robbery case, a $50,000 secured appearance bond in the probation violation, that's number 34 on the calendar, and I will keep the $5,000 on the JTOP FTA because that is strictly for being on probation for a serious felony and blowing off JTOP. Right now, I will give you a chance to speak, although because I will say that ups your bond to $130,000. I'm not going to at this. Well, I'd have to set it in all the cases, and he's on probation. You know what? I will order the ankle monitor in the new case only, and this is because the court believes that, pardon me, with a younger population, ankle monitors tends to have a more significant effect on controlling behavior. That being said, in your case, the court believes that that is not remotely sufficient to help protect the community against your potential danger and high risk of non-appearance. Now, you can speak, Mr. Cheatham. I've appointed a lawyer for you. You have the right to remain silent in all of these matters about what you're being accused of. Do you understand you have the right to remain silent?
Yes, ma'am.
And do you understand that this hearing is being audio and video recorded
and streamed on
and things that you might choose to say about what you've been accused of, which can be very tempting since two other people just did it. It can be tempting to want to respond. You are unable to respond without your statements possibly being used against you today or any later hearing, including your trial on what may be prison mandatory charges. Any new felony for you is potentially prison mandatory because you've had you're on probation already. So you are facing potentially life-changingly serious consequences. Your lawyer can tell your side of the story without it being held against you, but your lawyer's not here today. So I always recommend that whatever defendants want to say, they confine it to what conditions of bail or release the court ought to set rather than talking about what you've been accused of. Because if you want to tell me your side of the story in an attempt to get me to lower the bail by saying things that may literally get you put in prison, then you are not understanding the nature of the right to remain silent, and you're making a bad decision. If you're trying to get a better bail on the by saying things that could be used against you, that is not a good idea. So do you understand that warning I just gave you?
Yes.
Do you want to say anything about what conditions of bail or release I should set?
I was just gonna say something about the J-top warrant.
Mhm, go ahead.
I never knew I had a J-top warrant. My phone was like off for like 2 weeks,
Oh, I hate when my phone.
and then when my phone got turned back on, I guess my probation officer told me that I had a warrant out for my arrest. They told me that they sent
He's a
mail
damn
through the mail and stuff, but I had never got it for.
No way at that age
for
you're gonna be able to have your
J-tops.
phone off. You're
All right, well,
coordinating
talk to your
social
lawyer
media.
about that. It looks like that they reset it at least twice, and that Judge Koval was, had a chance to listen, no, this says, I'm sorry, July 16th, you were present. And they set a court appearance for yesterday at 10:30 in the morning. And the warrant that went out was indeed yesterday. And your arrest time, well, the police allege they arrested you around 6 p.m. yesterday. So you were physically present in court when your court date that was yesterday morning was given. You were arrested till yesterday evening. So you straight up failed to appear. I can see it in the docket. So talk to your lawyer about that. Frankly, Mr. Cheatham, that is the least of your concerns right now. So talk to your lawyer about that. You're going to end up with the same lawyer for everything. And you can talk to your lawyer about everything that just happened today. Did the state have a motion on the new case? Is that also why you're here?
Yes, Your Honor. The state would move to seal the Form 4. I think there's two versions, the original and then a superseded. We would request to redact both of those, or excuse me, to seal both of those and replace them with the redacted versions. They include the victim's name for the new case. Additionally, the case that he is currently on probation for, there was a minor co-defendant whose name and date of birth was listed in those as well.
Okay, all right, so that motion is granted. I've re-signed it. Let me make sure my staff re-closes it so that it takes. And so, Mr. Cheatham, that's just because the police have included some information in the booking paperwork that is not supposed to go into the public record per court rules. And so the state is supplying a redacted copy, meaning that stuff will just be whited out. And then, but you and your lawyer will have access to discovery in the normal case process. This just has to do with what goes up on into the public record right now. So talk to your lawyer about that, but we don't deny those motions, that this is well taken. I'm glad they're making it. I grant it, but you can talk to your lawyer about that. Everything's going to be on your paperwork. And did you want to be excused for now or stick around, Ms. Gaunt?
I'll just stay, Your Honor, until the matter with counsel. Thank you.
Okay, sounds good. Thank you. All right, so Mr. Cheatham, if you'll step to your left, we're going to give you paperwork for everything. Thank you. Mr. Trujillo, Ramon Trujillo, and then Destiny Mestas, will you please go to the chair? Hello, sir. May I have your full name and your date of birth?
Ramon Trujillo III, 6286.
Got him.
Okay, it sounded like you said Trujillo. Did you say Trujillo?
Yes, ma'am.
Okay, thank you. You're here on a total of 3 things. One is a new felony arrest, one is a probation hold, and one is a traffic misdemeanor warrant. So I'm going to start with the new case. You've been booked in for theft of a means of transportation, a Class 3 felony, dangerous and narcotic drug possession. Those are Class 4 felonies. There is probable cause for all of those. And I am appointing a lawyer for you in this case and in your probation case. The probation department will be filing a petition to revoke your probation based on this new arrest. So you have to go to probation court as well. Your court date in probation court is October 9th, 1 week from today, 8:30 in the morning. In the new case, your court dates are, I'm not sure if I just said this, a status conference October 8th at 8:30 and a preliminary hearing October 10th at 8:30. So all of those are next week. In the new case, your bond is $5,000 secured. In the probation case, it is $1,000 secured for $3,500 total. Now, you're also here on a warrant from the South Mountain Justice Court for failing to appear in a driving on suspended license case. It's a Class 1 misdemeanor. Your court date there is going to be October 6th, which I think is Monday, yes. Monday the 6th at 8:30 in the morning. That address is on your paperwork, and your bond in that case is $500 secured. That's the driving unsuspended. And I did appoint a lawyer for you just in the event you're not able to post bail. Then you will have a public defender at that hearing to help you on the bail issue only. We do not otherwise appoint lawyers in driving unsuspended cases. Everything's on your paperwork. If you step to your left, he's going to give you a copy. Ms. Mestaz? And then do you guys want to give counsel the high sign? He looks done, I just realized. I was waiting for him to come out, but I think his client is sleeping in there. Okay. Yeah. All right. So Ms. Mestaz and then Samantha Lopez. Yeah, and I want to do Mestaz first, please. Yeah. I didn't realize she was napping back there. All right. Hi, ma'am. Can I have your full name and your date of birth?
Destiny calling Mestas. My date of birth is August 30th, 1994.
Okay, thanks. And just for the DOs, you can leave Lopez in there or have her sit down. It's up to you guys. Okay, it's up to you guys. All right, Ms. Mestaz,
Yes.
you're here on a new case. You were arrested for theft, attempted theft of a means of transportation. It's a Class 4 felony. I am appointing a lawyer for you. Your next court date will be a status
I said I was
conference.
going to represent myself because...
Okay, and that is your right, but that is a very formal waiver of rights that we do not do in this court. So what we do is, I appoint a public defender for you. If that's what you want to do, your lawyer will literally help you waive counsel, but it has to be done in writing. There's a huge advisement. That is absolutely possible, just not today. So I'm going to give you a lawyer who will literally help you do that if that's what you want to do. So that's the reason I'm appointing a lawyer. It's not negotiable. I'm doing it anyway. But if you want to waive counsel, you could do it at a later hearing. All right, your later hearings are going to be a status conference October 8th at 8:30, preliminary hearing October 10th at 8:30. Those will be in the downtown Superior Court.
Okay.
Bond is set in your case at $5,000. It is secured. If you bond out, comply with all of your written conditions. That includes, do not go to the scene of the alleged crime, no contact with the alleged victim. You may not leave the state of Arizona without the advance written permission of the trial court. I am not giving you that permission. Absolutely no weapons, no drugs without a valid prescription. If you please step to your left, I'll give you a copy of your
Wait,
paper.
could I speak, please?
Sure.
Okay, so I'm going to be detained, correct?
I gave you a bond. If you post it, then you are released.
Okay, but until further notice, I will be housed inside the county jail.
I'm sorry, speak up.
I said, but until further notice, I will be housed inside the county
Until
jail.
you post a bond, yes, you will go to the,
Okay.
I'm sure
But,
you'll go to the Estrella jail.
Okay, but this was just a civil dispute. I mean, there wasn't burglary or nothing. I didn't break into this car or anything.
All right, the police have absolutely made probable cause for attempted theft of a means of transportation. So you can speak to your lawyer about that or do your own research on it, but the case is going forward and you'll have to post bail.
So my lawyer is going to be from California.
Okay, well, talk to them. It'll all happen down the road. All right, step to your left now, you can take your paperwork. All right, Ms. Lopez? And then Ricardo Trujillo, we go to the sheriff.
Oh, this is a lawyer. Somebody got a lawyer.
All right. Back on. All right, ma'am, may I have your full name and your date of birth?
Samantha Natasha Lopez, 9893.
All right, and then the appearance of the state, please.
Thank you, Your Honor. Brooke Gahn on behalf of the state.
And defense.
Good morning, Your Honor. Dominic Cleese with Law Office of DM Cantor on behalf of Samantha Lopez.
Thank you. Can you tell me your last name again? I'm not sure I saw it on the NOA.
Yes, Your Honor. Cleese, it's Callelse.
Okay, thank you. Just want to get it right. Okay, so Ms. Lopez, you have been arrested. In a new case, the allegations are aggravated driving under the influence of alcohol or drugs on a suspended license while impaired to the slightest degree. That's a Class 4 felony. Also, aggravated driving under the influence of alcohol or drugs by a third or subsequent DUI. That's a Class 4 felony. And possession of dangerous drugs as a Class 4 felony. All right, before I make any probable cause finding, did the defense want to be heard on probable cause?
Yes, Your Honor. Thank you, Your Honor. Regarding the second count, the third DUI within 84 months, it appears based on the probable cause statement that there is no second DUI conviction. It looks like Ms. Lopez was arrested and charged on September 26th of this year, but that is a current pending charge. So for that reason, I would ask that the court not find probable cause with respect to the second count, as this is not a third offense within 84 months. Regarding the third count, the dangerous drug possession, it does not appear that the officer did a preliminary or field test to confirm whether or not this was in fact methamphetamine, and so for those reasons, I would ask that the court not find probable cause for that as well.
All right, thank you. Ms. Gaunt.
Thank you, Your Honor. I think defense counsel is correct. I don't believe that there is a third DUI conviction. There is certainly a third arrest, but not a conviction. Additionally, although I do think they indicated that they believed that it was methamphetamine, I don't believe that there was either an admission or a field test. So I don't think there's probable cause on that charge as well, Your Honor.
Okay, thank you. Ms. Lopez, I agree with the lawyers that there's not probable cause on a third or subsequent DUI. There may be at some future point, but there's not today. And there is not, for purposes of this hearing only, probable cause for the dangerous drug possession. Neither of those is dismissed. I'm just ignoring them for purposes of release conditions. And you can talk to your lawyer about how that works.
Got it.
But right now, I'm not appointing a lawyer for you. You didn't do the financial paperwork. I did note Mr. Kalisis was a limited NOA, but your client did not do the financial affidavit. So, ma'am, I'm not appointing a lawyer for you in the event that you don't hire your own. You could fill out financial paperwork at a future hearing. It's an affidavit, and the court might appoint counsel for you then. I'm just not doing that today.
Okay.
All right. So I've got court dates coming up. Don't let me forget to give those to you. I sometimes forget when there's a lot of discussion. So before I set conditions of bail or release, what's the state's recommendation?
Thank you, Your Honor. The state is asking for a $10,000 secured appearance bond, and if Ms. Lopez is able to post that, we'd ask for pretrial services with alcohol and drug testing and monitoring, along with a judicial prohibition against operating a motor vehicle. The state is concerned that Ms. Lopez is an alleged repetitive impaired driver. As we have already referenced, she was arrested on September 26th, which was less than a week ago, for allegedly being impaired while she was driving. In that incident, she collided with a city vehicle. And it's unclear from the Form 4 whether she again was in a collision last night while she was driving impaired, allegedly impaired. The Form 4 seems to indicate there was front end damage to her vehicle, but that certainly could have been from the accident she had on the 26th. We are concerned that she is a significant danger to the community, given what appears to be some repetitive impaired driving behavior, and that she continues to drive, whether impaired or not, while she is legally prohibited from doing so, given the fact that her license is suspended. Given all of that, Your Honor, we think that that bond is appropriate to secure the safety of the community. Thank you.
All right, thank you. Mr. Kalisis.
Yes, thank you, Your Honor. So first, I want to start with the fact that I do not believe Ms. Lopez is a flight risk. She has no prior failure to appears. She lives in Arizona with her 1-year-old son. She is the primary caretaker of her son. She has no prior felony convictions. She does have the prior misdemeanor DUI conviction, and then the other current pending misdemeanor DUI offense. The damage from the vehicle that the officers observed, my understanding is that's the basis for conducting a traffic stop. The damage was extensive, but that damage was the result from the previous case, the first misdemeanor DUI involving the collision with that vehicle. There was not another accident in the DUI offense that led to her arrest in this case. Ms. Lopez does suffer from drug addiction, and she intends to check into a rehabilitation program once released from this hearing, Judge. So she would ask to be released to pretrial services so that she can, with drug testing, so that she can go to a rehabilitation program, which is really the root of the cause here, Judge.
All right, thank you. Ms. Lopez, I've considered what's been alleged against you, and I do note, counsel, pretrial is showing 2 prior felony convictions out of Florida. So if your client told you differently, that bears investigation.
I got another stream
This
running.
is listed as 2016 grand theft and 2015 grand theft. And Ms. Lopez also has a lengthy criminal history out of California, but like many California criminal histories, California does not spend a lot of time entering dispositions in cases. And so I'm assigning it the weight that I would give it. I'm not assuming they're convictions, but it is very long. It is multiple pages of arrests going back to 2010 out of California. So I've considered that, and ma'am, I've considered the apparent risk that you pose to the community and your apparent inability or unwillingness to comply with court orders like administrative suspensions of your license. The court is very concerned that you pose a risk to people in the community. Bail is set in your case in the amount of $5,000. It is secured. That means you can use a bail bondsman. If you post it, you will drug and alcohol test for the court. The court is including alcohol because what is alleged, which is, again, that literally doing this 5 days after the other allegations supposedly occurred. I agree with the state. It was unclear whether the damage that they say, the heavy front end damage they allege they saw to your vehicle yesterday was from a collision a week ago or from a collision yesterday. But the court is very concerned that people who repetitively commit this type of offense tend to hurt and kill other people with their cars. So you are categorically prohibited from driving without the further order of the court in this case. That means even if you got your license back tomorrow, you may not drive. You need to get a court order for that. In this case, alcohol and drug testing is mandatory. Pretrial is not allowed to remove that on their own. They have to get the court to do it. No weapons, as far as this court believes. You are a convicted felon. No drugs without a valid prescription. No alcohol. And again, this is two places in your paperwork. You may not drive any motor vehicle at any time. All right, anything else from the state?
No, Your Honor, thank you.
Defense.
No, Your Honor, thank you.
Okay, we're going to get that printed up for you, ma'am. And so I have lots of people left. If you want to keep using the room and it's okay with the DOs, you're welcome to.
Perfect. Thank you.
Thank you. All right. Okay, are you sticking around with us? Yes, you can. Thank you. Have a good day. All right, we're going to go on to Ricardo Trujillo, please, and then Nicholas Baker, if you go to the chair. And I didn't give the dates, by the way. They'll be on the paperwork, but they are the 8th and the 10th. I did that thing. All righty, Mr. Trujillo, can I have your full name and date of birth?
Ricardo Valentino Trujillo, 10-10-88.
Okay, thanks. You're here on a new case. You were arrested for possessing narcotic drugs, a class 4 felony, and unlawful use of a means of transportation as a passenger. It's a class 6 felony. There is probable cause for both of those, and I am appointing a lawyer to represent you. Your status conference will be this Wednesday, October 8th at 8:30 in the morning, with a preliminary hearing October 10th at 8:30. Those will be in the downtown Superior Court. Based on your criminal history, bond is set at $2,500. It is secured. If you bond out, comply with all of your written conditions. That includes no contact with the alleged victim. That's whoever owns the allegedly stolen car. No contact with your co-defendant, who appears to be your brother. And obviously, no drugs without a valid prescription. If you step to your left, you get a copy of your paperwork. Mr. Baker. And then Amy Short, will you go to the chair, please?
Amy.
Hello, sir. Can I have your full name and your date of birth?
Nicholas Baker, 7/22/99.
All right, thank you. You're here on two things. One's a new felony case, and one is a traffic misdemeanor warrant. I'm going to start with the new case. You were booked in on allegations of possessing narcotic drugs for sale, a class 2 felony, possession of narcotic drugs, and possession or use of a weapon during the commission of a drug trafficking crime. Those are both class 4 felonies. Also possession of drug paraphernalia, which is a class 6 felony. There is probable cause for all of those, and I am appointing a lawyer for you. Your next court date is a status conference, October 8th at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be October 10th at 8:30 in the same court. Your bond in this case is $2,500. It is secured. That means you can use a bail bondsman. If you bond out, comply with all of your written conditions. That includes no weapons, no drugs without a valid prescription. You're also here on a warrant out of the Ironwood Justice Court in a criminal speeding case. It's a class 3 misdemeanor, and you failed to appear last October in this case, and a warrant went out for your arrest. So your arraignment hearing is going to be October 6th, which is Monday, 8:30 in the morning in the Ironwood Justice Court. In this case, in the absence of the felony case, I might have given you a do-over, so I'm just going to set what's called a placeholder bond. It's $50 secured. That's on the traffic case. That's in case you don't post bond in the felony case. If you don't post bond, then when you get to Justice Court, you'll have a public defender there just to help you with the bond issue only. We don't otherwise give people lawyers in criminal speeding cases. You do have a lawyer in the felony case, though. So your total bond is $2,550. Everything is on your paperwork.
Okay. How could I get a bail bond or whatever? I don't have.
They take calls from the jail, so the officers can show you where the phone numbers are. You can call them from the jail.
All right.
All right. Thank you, Ms. Short, Amy Short. And then Jaquel Dillard, will you please go to the chair? Hello, ma'am. May I have your full name and your date of birth, please?
Amy Short, 2/27/79.
All right, thank you. You're here on 2 warrants, one in a felony probation case, one in a justice court case. Starting with the felony warrant, You are on probation for a Class 3 felony. Back on January 20th of 2023, there was a petition to revoke your probation filed. It alleges that you violated terms 6, 7, and 22. You'll get a copy of that from your lawyer. I am appointing a lawyer for you. Your next court date in the probation court will be 1 week from today, which is October 9th at 8:30 in the morning in the downtown Superior Court. That is a revocation, arraignment, and possible disposition hearing. The court address will be on your paperwork. You're also here on a warrant from the Encanto Justice Court in a case in which you've been charged with possession of an aggressive dog or an aggressive dog violation. That is a misdemeanor. And this warrant was issued out of the Encanto Justice Court on October 25th of 2022 after you failed to appear at a hearing in that case. And, oh, I forgot to check boxes on this one too. Officers, I'm sorry, I need to reprint the Justice Court case for Ms. Short. All right, ma'am, I just forgot to check any release conditions. Let's see, okay. In the probation case, your bond is $2,500 secured. In the Justice Court case, it is $500 secured. That is $3,000 total, and you're going to have written release conditions in both cases. They will be the same. No weapons, no drugs, no alcohol. Call your PO within 72 hours. The main number is on your paperwork. If you don't post bond, you don't have to call. If you do post bond, call within 72 hours of hitting the street. Everything's going to be on your paperwork. We just need to reprint the Justice Court paperwork, and we'll send it out to you. Thank you. Mr. Dillard? After that, Martell Johnson, will you go to the chair? Hello, sir. Can I have your full name and your date of birth?
Jonquil Dillard, February 5th, 1996.
Okay, thanks. You're in one new case and 3 probation holds. In the new case, you're arrested for possessing dangerous and narcotic drugs. Those are Class 4 felonies. There is probable cause for those, and I am appointing a lawyer to represent you. Your next court date will be a status conference in the downtown Superior Court this coming Wednesday, October 8th at 8:30 in the morning, with a preliminary hearing Friday, October 10th at 8:30. The probation department has notified the court they will be filing petitions to revoke your probation in all 3 of your probation cases. So you have to go to probation court for those. I am appointing a lawyer for you, and your court date for all 3 cases will be 1 week from today, which is October 9th at 8:30 in the downtown probation court. That will be a revocation, arraignment, and possible disposition hearing. In the new case, your bond is $1,000 secured. In each of the probation cases, it is $500 secured. That is $2,500 total. If you bond out, comply with all of your conditions, and call your PO within 72 hours. They have your paperwork for you. Thank you. Mr. Johnson, and then Ashley Young, will you please go to the chair? Hello, sir. Can I have your full name and your date of birth, please?
Martell Anthony Johnson, 090593.
Okay. I know it's cold, but can you take your hands out of your pants?
Yeah.
Okay, right. That's one that
Sorry,
is
I
a
know.
little weird on video.
Yeah.
All righty, sir. You're here on a new case and a probation hold. In your new case, you were arrested for narcotic drug possession, Class 4 felony, and drug paraphernalia possession, a Class 6 felony. There is probable cause for those, and I am appointing a lawyer for you. You're also here on a probation hold. The probation department will be filing a petition to revoke your probation based on this new arrest. So you're going to have slightly different court dates right now. Eventually, they will come together in the system. In the new case, your first court date is Wednesday, October 8th at 8:30. That's a status conference. Friday, October 10th at 8:30 will be your preliminary hearing. You'll go in between to probation court on October 9th at 8:30 in the morning for a revocation, arraignment, and possible disposition hearing. In the probation case, your bond is $500 secured. In the new case, can you get your hands out of your pants? Sorry. It's $50 secured, $550 with release conditions that will be on your paperwork. I'll let you step to your left.
$550.
$550, yes.
Secure what that means.
It means you can use a bail bondsman. All right, thanks. All right, Ms. Young, Ashley Young, and then Christopher Reichel, will you go to the chair? Hi, ma'am. Can I have your full name and your date of birth, please?
Ashley Young, 12/26/86.
Okay, thanks. You are here on a warrant in a pending felony case and a warrant from a justice court. I'm going to start with the felony case, and this is actually a newly charged case, not that new, that actually dates back to January. So there's been a criminal complaint filed against you, charging you with possessing narcotic drugs, a Class 4 felony, and drug paraphernalia, a Class 6 felony, back on January 8th of 2025, somewhere in Avondale. This comes from the Avondale Police Department. but you will get a copy of the charges and police reports from your lawyer. I am appointing a lawyer for you. In the traffic case, that's out of the West McDowell Justice Court, it is a DUI. You've already been convicted, a drug DUI. Class 1 misdemeanor from 2021. And in this case, the warrant went out September 9th of this year, and it is a failure to pay fines and fees or a failure to do things like usually it's drug education or testing or something. So they issued a warrant for you. Now, I have a question for you, which is, did you get bond in your other cases? I know you came in, Glendale probably has a hold on you, and you've got a West McDowell case. I didn't have time to look it up, and I'll tell you why in a second, but I'll literally take your word for it, because if you lie to me, you only hurt yourself. So
No.
did you get bond, or are you processing for release?
No, I received a bond from Glendale.
Did you post it?
No, because I was waiting to see what happened here, so that way it could be done all
Okay,
at
do you
once.
think you're going to be able to post bond in Glendale and West McDowell? Are you going to be able to? You think if I release you, which I'm willing to do, which is why if you don't end up released, you're going to catch a warrant in both of these cases, which is why I'm saying you're only hurting yourself.
Right.
I'm willing to release you because the felony case is not new. We just didn't have an address for you. You haven't missed any court dates in the felony case. And the misdemeanor case is post-conviction, and it's not a failure to appear either. So I'm willing to release you, but I will not do you any favors if you don't actually end up released. So do you know what your total is?
It's 400 right now.
Do you think you're going to be able to post it if I release you?
I'm going to try to.
All right,
I was going to
just so
wait.
you know.
Yeah, I was going to wait till Monday because my next court date for Glendale is Monday, and then depending
See if
on
you
how
can
it's
get
going
out
to go,
of it.
I was going to try to get out. Yeah.
And so that's why I leave folks in your situation sort of to the end of the bonds, because I'm willing to release you, and like I say, because you only hurt yourself if you lie.
Right.
So I'm going to change it to release. That's why I didn't give you court dates yet. And so just know that if things go bad and you don't end up getting out, when my court dates roll around, there's going to be a warrant issued for your arrest, even though you're sitting in sheriff's custody. That sounds crazy, but that is how it works. So I'm releasing you, which means they will not take you to court no matter how much you beg, because you are released.
Released, right.
All right. So in the new felony case, your court dates are going to be, we need to reprint, officers, October 16th at 8:30. So it's not for 2 weeks.
Okay.
Preliminary hearing October 20th at 8:30. I'm releasing you on your own recognizance because you just don't have that much or that type of criminal history. You're not without criminal history. I'm seeing 2 priors, they're drugs. So I probably would have just been willing to give you a chance anyway, because this is, again, drugs, and your priors are drugs. So just know that if you miss a court date and you were out of custody, nobody's going to give you a second try. We're just going to give you a bond. So go to court. It's the 16th and the 20th. It'll be on your paperwork for downtown Phoenix. That's the new felony.
Okay.
Then in the DUI, your justice court, did you reprint it yet? Okay, I got to take off the I got to take off the lawyer on West McDowell. Will you, read one more time? Okay. So the justice court case, I'm not giving you a lawyer because you've already been convicted. You only get a lawyer if you get a bond. I'm not giving you a bond. So I'm releasing you in West McDowell. That's going to bump your court date out to the 14th of October at 1:30. So you do have a lot of time to make your way out of jail before this happens. Don't lose this paperwork. You know, if you lose it, you got a bad problem. You could always call the court and say, when's my court date? I'm not under any illusions that you're likely to do that. So don't lose the paperwork. Everything's on there. I hope you show up. If you don't, there won't be any sympathy, and we'll be able to see when you got released. You can't go, oh, I was in jail. We'll look it up. Glendale has their own city jail. If they hold you there, you got a different problem. We won't be able to verify it, and we won't take your word. So just go, okay? Everything's on your paperwork. The steps you left, we give you a copy. Good luck next week. If all goes well, you should be out in time for this. All right.
Thank you.
Sounds good. Mr. Reichel? And then Scott Humphrey, will you go to the chair?
Hey, Reina, thank you for the...
Hi, sir. Can I have your full name and your date of birth?
Christopher Reichel, September 19th, 1989.
Okay, thanks. You're on a new case. You were arrested for domestic violence, assault, disorderly conduct, criminal damage, and preventing the use of a telephone during an emergency. The first 3 are Class 1 misdemeanors. The telephone count is a Class 2 misdemeanor. There is probable cause for all of those. I'm not appointing a lawyer for you, sorry. Your arraignment hearing is going to be October 21st at 9 in the morning. If you want to try to qualify for court-appointed counsel, you have to fill out paperwork at Peoria City Court. They may or may not do it. That is their decision. I'm releasing you on your own recognizance with no victim contact orders. From the way the police gave me the probable cause, it appears the alleged victim does not live at that location. They didn't say whether you did or you didn't, but she appears not to live at that location. So I'm not ordering you not to go back there. Sounds like it's your common parent's house.
Yes.
Are you living there?
Yes.
So I'm not prohibiting you from doing that, unless your parents kick you out and then you got a different problem.
Yeah.
That's between you and your parents. They're not victims in the case. So if your sister comes over and your parents tell you to leave so she can come over, you got to do it, because if you stick around and she shows up and the police get called, you get arrested.
I understand.
So, absolutely no contact with your sister, even if she shows up at the place you live, because I cannot, nor would I, order her not to go to her parents' house. She's the alleged victim in this case. So she's under no court order to stay away from you. You're under a court order to stay away from her, which is enforceable by criminal statute. So it's a criminal case. Don't monkey with it. It's not an order of protection. It's a criminal release order. There will be consequences if you get arrested for violating it. No weapons, no drugs, no alcohol. They accuse you, and there appears to be some evidence of being an alcoholic. I'm not going to make you alcohol test. I can't do that in a city court. I'm saying
I understand,
you're prohibited from drinking. No weapons or drugs without a valid prescription. If you get served with an order of protection, then you have to comply with that as well. Only if somebody serves it on you. And that would be anybody. Like if your parents were to serve one on you, you're stuck complying with that. Anyway, everything's on your paperwork, but based on your criminal history, I'm willing to release you. I'm not seeing a pattern of this, and I'm not seeing, I see a DUI, I see drug paraphernalia, and an FTA. So I'm not seeing, I see an old, by the way, everything sticks around. 2009, you were arrested for criminal damage, domestic violence, but it got dismissed. So I'm just saying, we get granular detail on some of these criminal histories. So I'm releasing you. Don't monkey with release conditions. Everything's on your paperwork. Don't miss your court hearing.
Yes.
All right.
And I'll have to do my research, but are those charges that she can still drop?
No.
Technically?
No, she's not up to her. So, and by the way, witness tampering is a felony. Attempting to influence a witness's testimony is a felony. Committing one act in violation of my no contact order is aggravated harassment, a felony.
Understood.
I put the statute in your paperwork. Google that or aggravated harassment statute. You could send her one text, and if the police booked you in and the court found that that text was harassment, that is a felony. So serious consequences. Your court date is not for 3 weeks, October 21 at 9 in the morning. I believe you should be able to comply with these release conditions without a lot of effort. If you prove us wrong, you'll find out what happens, whatever that is. So it sounds like you understand it, and you'll comply. Yes?
Yes, ma'am.
Great. Then you are released. It still takes many hours to be released. Try to be patient. That's just part of the joy. But you should be out hopefully by dinner time tonight. All right.
Okay. Thank you, Your Honor.
All right, Mr. Humphrey. After that, Elvis Klein. We go to the chair, please.
Hey guys, just gonna give you guys a heads up. I'm gonna be getting off in the next few minutes.
Hello, sir. May I have your full name and your date of birth?
I'm gonna leave the stream
Scott Humphrey, March 17th, 2003.
All right, thank you. You were arrested for reckless driving, a class 2 misdemeanor. There is probable cause for that, and I am appointing a lawyer. No, I'm not. Sorry. I just say that so routinely. I'm not appointing a lawyer for you. We don't in this type of traffic misdemeanor unless you get a bond. I'm not planning to give you a bond today. I thought about it, and I will say that what they allege against you, as I noted in my order, appears to be particularly egregious and very deliberate. And it's the kind of behavior that the rest of the people on the road wish there was a cop around to see when somebody does it, because splitting traffic, cutting tightly in and out between cars on a motorcycle, startles drivers and can cause people to die. And, the recklessness that they allege against you could easily be charged as aggressive driving, which is a class 1 misdemeanor, more penalties. The state could still do that. But we do not set bail based on how much we dislike what a person is accused of. We set it based on objective considerations of whether we think they're likely to appear,
if you will,
whether we think they're likely to commit new crimes, whether we think they're likely to comply with other release conditions. You don't appear, the police did not tell me that you have any other criminal history. I don't get it separately in a misdemeanor case. The police have to do it. They didn't say that you've ever even been arrested before. So I'm going to presume that you have not, and that you don't like being arrested, and that they very likely impounded your vehicle for at least a month, which would tend to reduce the likelihood that you might commit this type of crime while you are pending this case. I will tell you that this exact type of driving behavior, if someone is hurt, could get you charged with aggravated assault. If someone is killed, could get you charged with second-degree murder by gross recklessness and extreme indifference to human life. So, with that lecture,
Okay, someone
and
raise the
hoping
volume up
that
for my
the
microphone.
overnight in jail was very unpleasant, such that you wish to avoid that in the future, I'm going to release you on your own recognizance to go to court October 22nd at 9 in the morning. I considered also ordering you not to drive. I have not done that because, again, we don't set bail based on how much we might dislike what someone is accused of and how many times we might sign warrants and do these hearings for people who do get accused of murder based on speed alone.
Is this better? I just raised up my
Mr. Humphrey,
microphone
will you
25%.
comply with these
Can you
conditions
guys hear me
and
better
come to
now?
court?
Is it the
Yes.
same?
All right, then you are released. It still takes many hours to be
Or
released.
is 50%
Try to be
better?
patient. If you step to your left, he will give you your paperwork.
So this is
Thank
50%. 50% or 25%?
Mr. Klein?
What's better? This is 50 right now.
And then Sabrina Sedana, will you go to the chair? Hello, sir. Can I have your full name and your date of birth?
Elvis Christian Klein, and it's 5799.
Okay, thanks. You're here on a warrant from University Lakes Justice Court in a criminal trespassing case. It's a Class 2 misdemeanor. This is a failure to appear warrant, and your arraignment hearing is going to be October 21st at 1:30 in the afternoon. That's about 3 weeks from now. I'm going to release you on your own recognizance because I looked at the court record and I saw that you've been to court at least a couple times. This is your first warrant, and it is criminal trespassing, which is on the continuum of offenses, less dangerous. So it's your first warrant. I am going to give you a do-over. Don't blow it, because then you'll come back and somebody will see that you came through jail,
really quick. I want to check
you
my
got a
microphone.
do-over, and you blew it off. Don't blow it off. Show up. I know you know how to call them because their court record says you called them before. So if you have trouble getting there, call and ask for a different court date. They'll usually do it if you do it before the warrant goes out. So give them a call if you can't make it. You got 3 weeks to get there. Will you do that?
Yes, ma'am.
All right. Also stay away from wherever this was.
Okay, wait, so am I still trespassed from ASU?
That, I'm ordering you not to return to the scene of the alleged crime. If that was ASU, then yeah. But I'm not they trespass you. The ASU can say you are disinvited from ever setting foot on our property. They do that. What I do in the criminal case is I prohibit you from going to the scene of the alleged crime. Sometimes I know that might be the entirety of the ASU campus. Sometimes I don't. It's also true to say that I don't know when somebody might be a student and when somebody might not. But if you've been trespassed from ASU, they don't forget.
Yeah,
so you're going to get arrested. You could also be booked in for the misdemeanor of violating this order. So all I can tell you is, if you believe you have a legal right to be there, that is between you and ASU, because they can trespass people who are full-time, fully paid students. They can trespass them. So that's a civil issue right now. They haven't, I'm not being asked to find probable cause because this is an old case. Probable cause is already found. This is just a warrant. If you go there again and then they book you for it, I would have to find probable cause, but this is a pending case. So I don't even know what you did, except now you have sort of told me. So, or allegedly did, sorry. I'm releasing you. Go to court. That's the main thing. Stay away from wherever this was. Everything's on your paperwork. You'll be out in a few hours. Be patient. If you step to your left, you get that paperwork.
All right.
Thank you. Have a good day.
Good luck.
So I'm
Ms.
gonna get
Madonna,
going, but
and
if
then
you guys,
Robert
like I said, if you
Bender,
guys
we
want
go
to
to the
continue watching, jump on over to YT. I'm gonna leave the stream running. All right. I do
Hello, ma'am. Can I
appreciate
have
you
your full
guys.
name
I
and your
am
date of
Colette
birth?
James. You are
Sabrina
watching
Marie
out with
Moreno
Colette from.
Saldana,
And with that, I'm
252,000.
out.
Okay, thanks. You are before the court on a total of 3 things. One's a new arrest, 2 are probation holds. In the new case, you were booked in for possessing narcotic and dangerous drugs. Those are Class 4 felonies. And the probation department has notified the court that they plan to file petitions to revoke your probation in both of your cases. Looks like you're on probation for 1 felony and 1 misdemeanor. So I'm going to give you a lawyer in all of the cases, and I'm going to give you some court dates. The first one is going to be October 9th, which is 1 week from today. That's the probation court date at 8:30 in the morning. It's on your paperwork. It's in the downtown Superior Court. Then the week after that, you're going to go for the new case on October 16th. That's a status conference, 8:30 in the morning. Preliminary hearing, October 20th at 8:30. So you don't have any other conditions in this case. I did check the box to give you the probation phone number because your terms and conditions require that you call your PO within 72 hours of any release from any jail. So don't forget to do that. I didn't find probable cause for the drugs, though, for purposes of this hearing only. So you're entitled to be released with no other conditions. You don't have bond. I'm not ordering you to do anything. I'm reminding you to call your PO, but otherwise you don't have any conditions. Because what the law says is that when I don't find probable cause on a new charge, you're entitled to be released, but I do not dismiss cases. The county attorney can still go forward on this, which is why I gave you a lawyer and I gave you some court dates. Otherwise, you're going to get released.
So I'm getting OR?
No, I guess I'm saying it's not even OR.
Yeah,
You're just released.
Right.
You don't have to promise me anything. You're just released. OR is your promise to do things. You don't have to promise anything. I didn't find probable cause.
Okay,
I'm just telling you, your
saying.
terms and conditions always require. You call your PO within 72 hours of release.
Okay.
I click the button on everything because it prints the phone number. Then you have no excuse. You can't come, you didn't know my PO's number. Yeah, you did. I gave you the main number. So just do it. And smart people, when this happens, they call their PO and they get right with their PO.
Because I've been doing good for 13 months.
You need to keep doing good. Be upfront with your PO. Be straight with your PO because this is a temporary situation.
Yeah.
I would stake my life about what these drug results are going to be, but it's not probable cause. It doesn't matter what I personally think.
Right.
It matters whether the police met the standard. They did not. You are entitled to be released. So get right with your PO. That is the best thing you can do for yourself while this goes through the system. They may well wait for lab results and you don't end up charged for 6 months in this case. The best thing you can do in that situation is be good on probation. So that's sort of life advice, not legal advice. All right, everything's on your paperwork. I did give you a lawyer. I gave you some court dates. Just don't lose it. Call your PO when you get out. They'll help you keep track of your court dates, and everything's on your paperwork.
Thank you.
No problem. Mr. Bender? Hello, sir. Can I have your full name and your date of birth? What's your name, sir?
Robert Bender,
What's your date?
32983.
Okay, thanks. Oh, Mr. Bender, I just saw that you have a DOC hold. Okay. All right. You got arrested for possessing narcotic drugs, a Class 4 felony, and drug paraphernalia, a Class 6 felony. I'm going to give you a lawyer and a couple of court dates. The first one is a status conference, October 16th. That's 2 weeks from now, 8:30 in the morning. Your preliminary hearing will be October 20th. I did not find probable cause in your case either, which means the police did not provide enough support for the allegation that what you had was narcotic drugs. The case is not dismissed, but I must release you. I just saw that you have a DOC hold, though. So what's going to happen is DOC is going to get notified that you got released. They will get 24 hours to pick you up. If they do, then you deal with them. If they don't pick you up and you hit the street, don't miss your court dates. It's all going to be on your paperwork because the case is not dismissed. I just have to release you because I didn't find probable cause for the drug.
Okay, can I ask a question?
Sure.
What do you mean by you don't find probable cause?
It means that, so the police have to give me a minimum amount, it's kind of specific, to establish that what you had was, they're alleging it's powdered fentanyl, but on powder, police aren't, legally speaking, they can't look at powder and go, no, that's fentanyl. Because sometimes it's meth, sometimes it's cocaine, sometimes it's baby powder. So they have to do a field test, there have to be some things. They didn't do that. So just like in most cases, do I think it was probably fentanyl? Yes. But they didn't meet the legal standard of proof, which means you're entitled to be released while the case moves forward. So I'm releasing you. The case is not dismissed. The county attorney can still go forward, but you are entitled to be released. Your problem is that you also have a DOC hold. So I'm releasing you in this case from this jail. The DOC is going to get a call, and they get 24 hours to come and get you. So I can't help you with that. I got nothing to do with you.
No, I do have a question with that. If DOC comes and gets me,
yeah.
Okay, I go back to prison. What happens with the case when I'm in prison?
If they go forward, it's going to end up in a warrant. It'll be put on you at the prison, and they'll bring you here before you actually get out of prison. If they don't charge it yet, if they wait for lab results, which they often do, you may get out of prison before they charge it. So it just depends on when the county attorney decides to charge it.
Okay, so would I'll be bedded today?
Sorry?
Or would I be put in a bunk today?
I don't know. Talk to the DOs. I doubt it because now you've been released and they're just waiting to see if your PO comes. So I doubt you might get a mattress if you get 24 hours, but I don't think you're going to get a bed. All right, if you step to your left, you get that paper. All right. Thank you.
Okay, thank you.
Yeah, no problem. All right, or officer, I've got Mr. Gutierrez Hernandez and Ms. Marin. As house calls, are they not physically present because they could pose a risk of danger to themselves or others?
Yes, Your Honor.
All right, I'm going to go to each of those defendants in person in-house immediately after this hearing to conduct their initial appearances in person. I will advise Atanasio Gutierrez Hernandez that he got arrested for dangerous drug possession, class 4 felony, and drug paraphernalia possession, class 6 felony. I did find probable cause, and I am appointing a lawyer for him. His next court date will be a status conference October 8th at 8:30, and a preliminary hearing October 10th at 8:30. And I'm inclined to set bond in his case in the amount of $500 secured for the reasons set forth in my written order. Andrea Marin, born 11/14 of 87, got arrested for aggravated assault on a correctional employee. That's a class 5 felony. And then multiple misdemeanors. Assault, disorderly conduct, 2 counts, criminal damage, and a 3rd count of assault is a class 3 misdemeanor. I will advise her that there is probable cause for those, and I am appointing a lawyer for her. Her status conference, provided I do release her, is going to be October 16th at 8:30 in the morning, with a preliminary hearing October 20th at 8:30. And I am going to release her to pretrial services. That's what's indicated by the risk assessment score, and it's also the state's recommendation. I believe it is appropriate. And my inclination is to order no uninvited contact with the alleged victims or her parents. So I'm going to go talk to her, and it's my hope that she will understand that order and be able to indicate to me that she will comply with it. She really doesn't have any criminal history, and it's not clear to me that her parents will not want to have contact with her. I am going to order no weapons or drugs, no alcohol. She has to obey any order of protection. And again, she's not to have any uninvited contact with the alleged victims, and she can't live with them unless they consent, and that consent must be ongoing. If it's revoked or if they never give it, she has to find alternative residence and bring proof to her next court date. Alrighty, everything is going to be on the paperwork. If anything changes after I see these 2 defendants in-house, my final written order will contain the court's ultimate ruling in these cases. I am not going to update the recording. Thank you. We are in recess.